Well, you just saw the verdict in this case. It is guilty on the charge of aggravated murder. But the question we have to ask, did the jury make the right decision in this case? Let's get an expert's opinion. With me now is former criminal law professor Marc Harrold. He's written a book called Observations of White Noise, an acid test for the First Amendment. Marc, so great to have you with us.
Thanks for having me on. Good morning.
Now, Marc, let me just first ask you, we look at the jury's verdict. It took them 22 hours, 4 days to come to this verdict. You've got a circumstantial case. You have a jury that's required to draw the inference that Yazid Issa provided these cyanide pills to his wife and basically planned and intentionally caused this murder. Do you think that because this is a circumstantial case, this took so long, or what do you infer in them taking 4 days to come to a decision?
Well, part of it is, they said they took a vote at the end. 4 days is a long time to deliberate, 22 hours or about 22 hours without taking a preliminary vote. From what I heard, they said they took the vote at the end. Thing about a circumstantial case is you always get the jury to fill in, some of the blanks. But when they have an unlikable defendant, sometimes that's easier to do. And I think probably what happened here is there was a lot for them to do. It was a circumstantial case. They wanted to get it right, and there were some steps that they had to take. I think that's why they asked for the evidence that they asked back to the deliberations about the capsule. They wanted to get it right. I think they took it slow. I think a lot of people thought it would be a quicker verdict in this case. But sometimes when you have an unlikable defendant that didn't show the kind of emotion that you would expect over a long trial, you have to fill in the blanks. It becomes a little easier for the jury to do. But I think they wanted to get it right, and I think they took about the right amount of time to do that.
All right. And, Marc, you talk about an unlikable defendant. You're talking about Yazid Issa. During this entire 6-week trial, I have not seen him show any emotion. I haven't seen him shed a tear for his wife, not show any caring. I mean, that's what I think we just see just on TV. As a defense attorney, what can you do about that? Because people are people, but at the same time, you've got a man who is being tried for murder. They're trotting out all this stuff about his past and how he's having these affairs, and yet he comes off as being evil and uncaring.
Yeah, absolutely. A lot of times you hear defense attorneys give advice and they'll say, look, don't show a lot of emotion. Don't, when you hear these things, keep a bit of a poker face. That can backfire a little bit. Look, it's a long trial and jurors are human. They are going to listen to the evidence. They're going to watch who's in the witness stand. They're going to watch the attorneys. But they can't help but to look over. We all think intuitively we're good judges of character. And we look over at somebody and we start studying the defendant sitting there for a long time. It's a 6-week trial, long time. And so the lack of emotion, I think, really hurt him. I think it came out that the icing on the cake may have been that he ran or he absconded. But the bottom line is here's how this individual acted before and after the trial, before and after the crime. The way that he acted in court really hurt him, especially when there was powerful testimony like that picture around Christmas time. And you just expect people as a human being, when you see something like that, if you're not the killer, or even if you are the killer, to have some emotion. I think it backfired. Maybe his defense attorneys told him, look, poker face, keep a straight face. But on this one, I think that backfired. This is a long time to study someone, and you expect to see some emotion.
Hey, Marc, let me borrow from your background as a former police officer. You have a case here where you've got Yazid Issa. He flees the country. This is the big problem that a lot of us had during this trial. He takes off. He thinks that he might be looked at, so he takes off. He leaves his kids. He does all these things. As a police officer, do you look at that kind of situation and start thinking, this person must be a suspect? Even if I wasn't really sure in the beginning, now I know that because he ran, he must have something to hide.
Yeah, obviously you have a presumption of innocence in our country, and as a police officer, you have to deal with the fact that he absconded if he's wanted, and you deal with him as a fugitive first. But look, nobody can help it. If somebody runs, it seems to make him look more guilty. It just can't help it. You think, look, somebody who had lost, a wife, somebody who had lost a family member, they would want to come forward and adamantly defend themselves so that you could go out and look for the real killer. Here, if you abscond, they're looking for you. They're going to put all their resources into looking for you instead of looking for the real killer. So I think, especially in a murder situation with a family member, can really backfire on you if you run.
Yeah, and Marc, one thing just during this trial, I've been getting so many tweets, Facebook messages, people have been sending me emails, and I think what a lot of people have said on the defense side is they've said things like, look, I saw Jamal Khalifi, I saw Firas Issa, all these guys are getting deals, and they're all getting deals to save their own skins, and that way it benefits them to say everything bad about Yazid Issa, as well as the mistresses. What do you say to that, and how does a jury look at things like that when you've got people who have done something wrong, but at the same time they're cutting deals and they're offering testimony against the defendant? Is the jury receptive to that, or do you think Because it seems like they were in this case, or do you think they are kind of leery of that and there might have been other factors that contributed to his conviction?
Yeah, I think if those witnesses were your sole source of evidence, you'd have a real problem. But I think most jurors know, even lay people know, look, around the criminal justice system, that's not true just of this case, but of a lot of cases. A lot of your witnesses who know a lot about what's going on in the criminal world or about crimes are going to be criminals themselves. So I think that most jurors take into account that they've cut a deal, maybe the fact that there's some bias, and are a little, hesitant with their testimony. But I don't think they discount it completely, because as we all know, a lot of the key witnesses in trials, whether it's because they rolled over an organized crime or they saw something because they were wrong place, wrong time, a lot of big-time witnesses are criminals themselves. And I think people just kind of understand that.
All right, Marc Harrold, former police officer, also former criminal law professor. You do both. Marc, thank you so much for joining us. We appreciate it.
Thanks for having me on.
All right, well, later